A federal district court judge in Washington, D.C. has just issued an order clearing the way for the first round of discovery to go out in a case against Donald Trump and Elon Musk's DOGE. Welcome back to Democracy Docket. I'm Marc Elias.
And I'm Paige Moskowitz. Let's get started.
All right, Paige, I am still going to refer to it as Elon Musk's DOGE, although I understand that now apparently Mr. Musk has nothing to do with DOGE. That's the subject of another video that you and I have done. But in any event, we got this very, very important order just, shortly a few minutes ago, in which for the first time, a federal judge is going to allow discovery. That is going to allow the plaintiffs in a lawsuit to issue questions, get documents, maybe even allow depositions, which are sworn interviews under oath, in a case that involves DOGE and Donald Trump's efforts to remaster the government.
Right, Mark, this comes in a lawsuit filed by Democracy Forward on behalf of various federal employees' unions. They're claiming that DOGE is seeking access to sensitive Department of Labor data, including information about medical and other benefits of all federal workers, information about workers' compensation claims, identities of vulnerable workers who sought the help of the Department of Labor for occupational safety or wage complaints. They also claim that DOGE is seeking access to information regarding investigations of Mr. Musk's corporate interests and the sensitive trade secret information held by the department, including those of the competitors of those corporate interests.
Yeah. And, it's interesting you mention the fact that one of the things they're looking at is whether private information was accessed, because that is something that the court singled out in this order. The judge said plaintiffs have thus far asserted theories of standing, likelihood of success on the merits, and irreparable harm that turn on whether individuals not permitted under the Privacy Act to view personal information are viewing or will view that information. Exploring that subject through expedited, targeted, and limited discovery thus should be beneficial. I mean, that is, to lawyers, a very big deal. For non-lawyers, what it means is that this judge wants to know and wants to let the plaintiffs find out whether or not people who are not authorized to access private information did in fact access private information. And so, Paige, you can see already the wheel spinning of where that could lead.
Mark, and this is a proposed order for limited discovery, right? So what does the process look like to actually get a discovery order?
Yeah, so what the judge did here was didn't actually rule on the specific discovery. The judge basically granted or indicated that he supported the position the plaintiffs had asserted in a prior pleading that discovery was appropriate. You see, normally discovery is not used in administrative law cases like this. Why? Because what you're really normally asking is just a pure question of law. Did the thing that the government do, did it comply with the law or didn't? And there's not usually a dispute about what the government did. The dispute is whether or not the thing they did, whether it was legal or not. Here, as the judge points out in his order, it's a little bit different because there's actually a set of factual questions, right? There is the question of whether or not the people could legally access the data. That would be like a typical kind of question. But there's a subsidiary question, or a question that comes before that, which is, who are the people who access the data? And were they even allowed to, were they even in the ambit of government employees allowed to access the data? So this is an unusual case. So the judge said, the plaintiffs, you have to come back, later today, by the end of the day, with your proposed limited discovery, which is reasonable because after all, the plaintiffs are presumably ready to go. They're the ones who want to expedite discovery. And then gives, the government until February 24th, which again is a very compressed time frame. Like in most cases, these things would be much, much longer, but gives them, 5 days essentially to oppose or respond. And then I expect we'll get a court order. We'll get a court order that says this is the discovery that's allowed. These are the people you can depose. These are the kinds of questions you can ask. These are the things you can't ask. These are the kind of documents you're entitled to. These are the documents you're not entitled to. Whatever it is, like wherever the court draws a line. And then we will see that discovery, I suspect, take place very, very fast. Again, this may not feel to those of you out there like things are moving at rocket speed. For courts, this is rocket speed.
Mark, the next question that comes naturally is if there's an order for discovery, How do you ensure that the government complies with it and that the plaintiffs get the information that they are entitled to?
All right. So, Paige, now you've asked like the big question, right? Isn't this the big question sort of hanging over all these cases? And you're right. In the case of discovery, it is actually much starker, right? Because the government has to comply by actually turning over the information. They actually have to produce the witness to sit at a deposition. And, there are several possibilities here. Number one, the government could simply seek to delay by saying, we're going to appeal the discovery order, right? And just try to make this like a side piece of litigation about whether the discovery is even appropriate. The second, we could see something like what we have seen in some of the other cases where they say, oh, when you asked for the log of who had accessed the computer system, we thought you meant the log for who had entered the building. We didn't realize that what you really wanted was about the computer system, right? We can see this kind of game of cat and mouse and misdirection that we've seen in a lot of these cases. But the thing is, that won't get them very far in a discovery case because the judge, is already teed up that he wants expedited discovery. So I think that would get slapped down. Which brings us to the third possibility, Paige, and this is where we start to inch closer and closer to a true constitutional crisis, right? I've said before, I don't think we are in a constitutional crisis. We are not in the place where the court's orders are being intentionally violated. Well, one of the easiest places to trip that wire, one of the most common places, frankly, where sanctions are imposed in litigation, even in normal civil litigation between corporations. One of the most common places where contempt is issued, again, in civil litigation, not having to do with the Donald Trump's administration, are in these discovery cases where a party just says, I'm not going to produce the document, or they delete the document, or a witness goes to a deposition and says, I'm not going to answer questions that they were ordered to answer. And so what is the chance, Paige? What is the chance that Donald Trump either instructs the departments not to comply, or the departments take it on themselves, or the Department of Justice lawyers refuse to certify that what's been produced is complete? Whatever it is, like, what is the chance that this winds up being a tripwire? Not insignificant.
Marc, and let's say that the order goes through, discovery happens, the government turns over everything that they're supposed to. What kind of information could we be looking at? How insightful or clarifying could it be to get these sorts of records into the scope of what DOGE is doing? And maybe more importantly, who is a part of DOGE?
Right. And I think that you put your finger on it again, as usual, Paige. You're smarter than the rest of us, right? This case, though it is about DOGE in this one agency, right? DOGE in the Department of Labor, accessing confidential information. It doesn't sit, though, in a vacuum, because other courts in other forums have been told things by Department of Justice lawyers, and they all need to jive between courtrooms, right? Like, I mean, the Department of Justice can't tell one judge, oh, Elon Musk has nothing to do with DOGE. And then in this courtroom, it turns out like Elon Musk is running DOGE on the internal documents. I'm not saying that's what it is, but like you're going to start to see, as these cases progress through discovery, there's going to have, whether or not there is in fact a consistent paper trail, a consistent understanding by witnesses, a consistent set of arguments that Department of Justice lawyers are making. And discovery is, one of those strands that is hard for the administration to get around. It's one thing to send the Department of Justice lawyer in to say something like Elon Musk, has nothing to do with DOGE, right? Like we can all be like, huh? Right. But it's another thing once you start producing the internal emails of people who say, well, we have to answer to Elon Musk because he heads DOGE, or, whatever it is. They've refused, I believe, Paige, you tell me, I think they've refused in another case to actually identify if it's not Elon Musk, who it is that runs DOGE. Like this is the kind of thing where you might actually come across a document that says this is who runs DOGE. So it's going to be very interesting to see how the administration, how the Department of Justice tries to square all these cases up.
Right. The White House made that claim earlier this week in a lawsuit from 14 Democratic state attorneys generals who claim that DOGE is illegally organized and Musk is an unconstitutionally appointed principal officer of the United States. They're seeking to nullify and block all actions that DOGE and Musk have taken. But earlier this week, Joshua Fisher, the director of the White House's Office of Administration, wrote in a court filing that Elon Musk is not a part of DOGE. He is not the administrator of DOGE. He is a special employee of the White House and has nothing to do with DOGE.
Right. So do you think that's going to square up in the discovery in the Department of Labor? Maybe.
Or maybe there are records showing that Elon Musk showed up at the Treasury Department or the Department of Labor seeking information.
Right.
So, I mean, that's why, like you said, discovery is really important. But I have one more question I want to ask you. So the judge in this Department of Labor case denied the plaintiff's motion for a temporary restraining order to block DOGE and Musk from getting access to this Labor Department data. How does it square away that you deny this motion for a temporary restraining order, but then follow it up a couple weeks later saying, no, I agree, you should get access to some documents because something doesn't sound quite right?
Yeah. So look, the standard for a temporary restraining order is just different. It's like different than anything else in the law. And because what you're asking a judge to do with a temporary restraining order is oftentimes on little more than a single filing and a few hours, you are asking a court to block some action. Okay. You're literally going to the judge and saying, if you don't act immediately, and by immediately, like within minutes or hours of the filing, of the argument rather, then, there will be irreparable harm. And so you have started to see, Paige, in a number of cases, the judges start to decline issuing or deny issuing temporary restraining orders. And part of what they're saying is like, look, this isn't either as much of an emergency as you are saying it is, or you waited a little bit of time. Like if this was going to be such an emergency, you should have shown up a few weeks ago when this all started. Or they're saying, look, there's just not enough in your filings for me to know what's going on here. It's not clear enough to me what the facts are of this case. So in this instance, I think that's what the judge was saying, is that last thing is like, I don't really understand enough to know who the plaintiffs are here, what their injury is, what's the defendant's theory, like who's doing what. And so that's why he denied the temporary restraining order. But that doesn't mean the lawsuit's dismissed. That just means that very, very short period relief is denied. But the case still goes forward. And the next stage in these cases is what's referred to as a preliminary injunction, which sounds a lot like a temporary restraining order. But think about temporary as like, I need relief today, and it only has to last 14 days, which is usually the period that a temporary restraining order can last. A preliminary injunction is, okay, Your Honor, I need a decision like in the next few weeks. Like I don't have months to wait, but I have days to wait. Like, and we can, by the way, Your Honor, do a little discovery, and we can also put on some witnesses, and we can also submit longer arguments and briefs, right? Like, there's enough breathing room here, Your Honor, that it's not going to be a full trial. It's not full discovery. It's not all of the bells and whistles, but you can have a hearing and sort of get more of your arms around this case. And so that's where we are in this case. That's where we're frankly going to be in a lot of these cases in the next couple of weeks. They're going to shift out of this sort of emergency relief into this sort of temporary relief. And, temporary restraining order is a bit of a misnomer, Paige. You and the Docket team cover all these cases. The preliminary injunctions in these cases are not that preliminary. They oftentimes are in place for months or even years. They are preliminary only in the sense that they are in effect essentially till the trial is over. And, given the speed with which the federal courts right now have trials, that can be a matter of years. So really the action for most of these cases is going to be at that preliminary injunction phase, not at the temporary restraining order phase.
Marc, big news today about the discovery order. What else should we know?
Look, I think that what we need to know is that this is not going to be one or two lawsuits that get decided quickly. This is not going to be, Donald Trump does something terrible in January, early February, and by the time we hit the middle of March, it's all resolved in the Supreme Court's rules. Like, that's just not realistic. And so everybody watching this needs to just settle in for the long haul. I know you're tired. Okay, believe me, I'm tired. Paige is tired. But now is not the time in history to be tired. Like, now is the time, get yourself some coffee, get some caffeine, do what you need to do to wake up, because we are entering into a prolonged period in which the courts are going to be central to whether or not democracy survives. The courts are going to be the courts are going to be in the news every day for a long period to come. And you cannot tune it out. You cannot look for short answers, and you cannot look at any one case and say, okay, this case is going to decide everything, or this case, if we lose, means all is lost. That just isn't the way it's going to work. It's going to be a lot of hard work by a lot of lawyers and a lot of legal organizations doing a lot to fight against this. And we're going to hopefully have judges who stand up for democracy in court, which is, after all, Paige, like the central mission of what Democracy Docket exists to cover, right? I started Democracy Docket in 2020 to be the leading source for news, information, and analysis on everything happening to democracy in court. It now has, I think on one of the videos I said it had 17 people. It now has 19 people, and it has 350,000 subscribers. So please, if you're not already one of those and you want to support the work of those folks, click on the link above and become a subscriber to Democracy Docket today. And we will see you next time.